Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. Well, Constitution is not merely a lawyer's document, it's a vehicle of life and its spirit is always the spirit of age. That was Dr. B.R. Ambedkar, who was the chief architect of India's Constitution. So joining us today on the Virtual Amicus is someone who believes in the Constitution, who defends it, and who's argued a number of constitutional matters before the Honorable Supreme Court, various high courts in the country. Today, we are joined by Mr. Bhavik Lalan, who's a counsel at Bombay High Court, who is also presently associated with the esteemed chambers of Shri Mr. Sanjay Jain, and he will be dealing with two very important topics. The first being the basics and nuances of the Places of Worship Act 1991, and secondly, constitutional law practice. Now, first, I'll give a brief introduction about the amicus for today's session. Mr. Lalan is a young MCI member, trained tribunal secretary, is also trained mediator, the Maharashtra National Law University, also impaneled as certified neutral with www.sama.live, which is an online dispute resolution platform. Now, he started his practice as a solicitor from Bodhanwala and Company in Bombay as an article clerk for solicitor's examination. Has also appeared for that back in 2013 and 14. Joined Cyril Amarchand Mangaldas in their dispute resolution team. Started as a counsel practitioner from January 2018 onwards. He's also associated with esteemed chambers of Sri Sanjay Jain Saab, and is an arguing counsel practicing before Bombay High Court for the last 25 years. He's been part of various constitutional matters pending before the Honorable Supreme Court of India. These matters involve questions of basic structure, fundamental rights, and its correlation with Schedule 9. He's also had the privilege to draft the intervention application to appear before the 9 judges constitutional bench of the Honorable Supreme Court of India to successfully get an IA admitted in the Sabrimala case. He's also represented various charitable and religious trusts before the Charity Commissioner, Bombay High Court and Supreme Court. And at present, he is currently pursuing he's in his final year of MA Executive in Mediation and Conflict Resolution from Maharashtra National Law University, Mumbai. His first 2 years, UGC approved master's course in Indian and Asia on practices on mediation and conflict resolution. So thank you so much, Mr. Lalan, for taking out of our time and doing this. Now, before we start with our Q&A segment, it is very important to understand why this topic was chosen. Was it chosen because it has been all over social media? It has been in the news for all the possible reasons whatsoever. It is important to understand that why this act was enacted in the first place. Why was it notified? What were the circumstances, the history behind the same? Was it only to prohibit conversion of any place of worship, or to provide even maintenance of that religious character of any place of worship? So does it apply to every possible place of worship? From when does it apply? Is it exist from the day of Indian independence, which is 15th of August 1947? And when does it fall under the control of archaeological survey? When can the structure be changed, the dimensions be changed? So, Mr. Lalan, we now need your assistance. And if you could say a few words about the channel before we start with the Q&A segment.
Sure. Thank you, Jay. Thank you for having me here on your virtual platform. I have been observing the activities of the virtual amicus for last 2 years, and I must say that the lockdowns were made very interesting due to your channel and the way how interviews were conducted by you and all the speakers who were part of this. I must first appreciate that this initiative has benefited many lawyers during the lockdown. And thank you very much to think of this. Now, first of all, why I chose to speak on this topic is that Constitution is something which is very close to my heart. It is one of my favorite subject and one of my favorite practice area in which I have now spent more than 10 years understanding the nuances, understanding the mindset of our apex court and the development which takes place from time to time in our constitutional mandates, in our constitutional reforms. The Places of Worship Act 1991 is an act which has a very strong backing and which has a very strong reason. Through our constitutional ideas, the framers of our constitution had an intention to have a secular country, to have a secular structure for India. India is a place where people from various class, creed, religion cohabit together. This country has witnessed that for thousands and thousands of years, all the people from various caste, race, religion have peacefully cohabited. And in order to fulfill that particular aim of our founders of the constitution, the parliament thought that it is really necessary to frame an act which will per se prohibit conversion of any places of worship and which will provide for the maintenance of the religious character of any place of worship as it existed on 15th day of August 1947, and for matters connected therewith or incidental thereto. Now, if you ask me from the interpretation point of view, which is this will be my personal view, of course, the the second portion of the aim of this act, which is already mentioned in the act itself, at the beginning of the act itself, very clearly indicates that matters connected therewith and incidental thereto. So the idea is that this act will be a twofold protection. One is that it will maintain the religious character of the place of worship, and the second is it will prohibit the conversion of place of worship. These are the core things which, even as a welfare state today, or maybe in the year 1947 when our country was declared as independent, the idea of the state was that a welfare state will ensure that there is a just, equitable, and a, and a peaceful environment in the country. To foster that view, to foster that aim, the parliament in the year 1991 thought it to be prudent to enact this law.
Well, thank you so much, sir, for this lovely introduction, giving the background, the historical significance to this, as to why you chose this topic, and two, why this topic is so essential for our viewers to understand, to know its nuances, its basics. So, sir, if you're ready, we can quickly start with our Q&A segment.
Sure.
So, so going ahead with our first question, according to you, why was there this compelling need to have a law like Places of Worship Act 1991?
So there was a situation where the country and the parliamentarians felt that if there are some religious places which are of significance, there are some religious places which may have some kind of some history, which may make those religious places prone to some adverse litigations, some kind of a kind of a I would say some kind of controversy may arise in respect of their past. The idea was that the peace in this country should not be disturbed, and therefore the parliamentarians of that particular relevant time thought that if such an act comes into effect, which will have an aim which is very clear from the act itself, and there is no ambiguity in my view that why the act was enacted and what will be the object of the act, and with a twofold view that this act will prohibit conversion and it will maintain the religious character. In my view, these are one of the best or the noble thoughts which prevailed at the time when this act was enacted in the minds of our parliamentarian, and the constitutional qualification to enact this act was very well supported, is even today supported, for the reason that in our preamble we have a structure where secularism is the core of our constitution. From time to time, the principles of secularism have been tested. And in that scenario, if state in fact fails to perform its obligation by not enacting this act, then that will be one of the unjust act by the state. So in my view, the act has a very, very, very deep and a very noble thought, or a very noble object.
So according to you, the object is noble for it to be notified and passed.
Yes, yes. And also, we need to ensure that the places of worship of each and every denomination, each and every religion, each and every section are protected in a manner where, subsequent to our independence, the worship, the 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 daily rituals continue to happen in a manner where the practices are not disturbed.
Peaceful coexistence, and all
Yes, peaceful
religions together
coexistence.
peacefully doing and performing their rituals without any problems whatsoever. Uh,
Yes.
so going ahead with our next question, what type of conversions are covered, one, and number two, protected under the Places of Worship Act of 1991?
Really very good question. Would you allow me to share my screen so that I can also point out from the section, from the act, that
Of course.
how this act gives you clarity on this question of yours? Is my screen visible?
Absolutely, sir. Absolutely.
Yes. So we can see that the definition of conversion, which talks about, which is section 2b, conversion, with its grammatical variation, conversion includes alteration or change of whatever nature. So, to me, if a place of worship belongs to X denomination, and in that X denomination, if there is any alteration in the place of worship, or if there is any change of whatever nature, then what you may do is, there are denomination in India who have sections in it. So, for example, if you change one particular type of idol into another particular type of idol, which may change its nature, or which may change the the nature of the worship, the manner in which the worship takes place, because sometimes you may have one particular type of idol which a one section may believe, or pray or worship. You may have another type of idol in the same denomination, but the subsection follows some different type of idols to be worshipped. Now, in my view, if there is a change in placing of such idols from what earlier existed, also amounts to conversion. And therefore, conversion is again twofold way how this act defines. One is alteration, second is change of whatever nature. And that includes, you may not change the structure of temple, or you may not change the structure of particular place of worship. What you may do is, internally you may make some minor corrections, or internally someone may alter the nature or the object of worship, and even that will amount to conversion, in my view.
So, but one quick question at this juncture: if you read the definition clause, if you
Sure.
pause here and read the definition clause, uh, 2b, which is conversion, with its grammatical variations, includes alteration or change of whatever nature. Now, what does the word whatever mean? Does it only mean the physical structure, the physical aspect of that? Or does it mean that the entire ceremony or the entire religious denomination can be changed? Or is it inclusive or is it exclusive definition? Because here they mentioned the word whatever nature.
So, Jay, in this question, I would like to first give an illustration, like how I explained you that there are denominations in India where we have sections in it. So it may happen that a temple may remain like this externally in the way how it was as on 15th of August 1947. But inside that temple, you place an idol which may not be of that of the subsection who initially built this temple, or you may change some kind of architecture of the temple in order to give it a view that this temple may belong to one subsection or to some another subsection. So these kind of alterations also amount to change of whatever nature. So usually people have an idea that if there is a temple, you pull it down and you build some another place of worship, only that will amount to a conversion only, or only that will amount to infringement of the provisions of this act. Then no, even changing the nature or giving any minor corrections which will indirectly change the whole course of practices to be performed in that particular place of worship will amount to conversion. So for example, a place of worship is being used or is being used by the worshippers of one particular subsect or a denomination for over years and years, and all of a sudden you just place something over here, or you just place or you just change a little bit of architecture inside, and you start claiming that now it belongs to this also and that also. This, in my view, also amount to conversion, though the denomination may be same, but the beliefs of sections and subsections are also included, and those beliefs are unique in my view, because I will explain you. If we can come to section 3, the section 3 reads like this, and please note that no person shall convert any place of worship of any religious denomination or any section thereof into a place of worship of a different section of the same religious denomination, or of a different religious denomination or any section thereof. So the conversion, even in the minutest way, will amount to breach or will amount to infringement of the provisions of this act. Over to you,
Sir,
Jay.
yes, sir. Now, going ahead with our next question, sir. Uh, what acts of conversion can be challenged, sir, under the Places of Worship Act? Is there any particular act, that probably breaches the provision that is enshrined under the statute? So what type of such acts can be challenged?
So what happens is that, as I narrated in my earlier answer to your previous question, section 3 is very clear about what particular how the conversions and what particular conversions will be considered to be act of conversion. So when there is change in the nature of worship, how we worship today, and if the nature of worship changes, also the acts of practicing some particular rituals in a manner, and then you all of a sudden change those rituals forcibly and impose some another rituals to be performed in a temple, in my view also amounts to conversion, because these cases are noticed in a denomination where you have various sections and subsections in it. And as I said, in India, we have uh, we have many denominations, we have many subsections and sections in it. And therefore, it is a constitutional mandate or a duty to protect them and to protect their individuality, to protect their unique, the uniqueness. And fortunately, the section 3 of this act ensures that not just the religious denomination, but also sections of the religious denomination get protection in it. And therefore, the wide view is to be adopted that one particular section has noticed any infringement in terms of change of the rituals or in terms of any forcible rituals being imposed on them, then definitely it amounts to conversion. And even those acts which are the minutest way of conversion are also included in the purview of this act. So if you ask me broadly, yes, if the structures are converted, it is an act of conversion. And minutely, even the practices and rituals, if forcibly converted or if forcibly imposed in a temple or in any object or in any place of worship, it will amount to conversion.
Very well, sir. Now, talking about the consequences, suppose there is a breach that takes place of the provisions of the act. Now, what are the consequences? Are they penal in nature?
Yes, in fact, the consequences are such that the like I will read it. Section 6 talks about the punishments, and there are penal implications in many cases, which we have also noticed that civil suits are filed. If you ask me, it is the state's duty to protect such kind of or to prevent such kind of conversion if the parties move before the constitutional courts. So section 6 very clearly says that whoever contravenes the provisions of section 3 shall be punishable with imprisonment for a term which may extend to 3 years and shall also be liable to fine. But the question arises that which will be the court of resort, or where will these matters be adjudicated? To that, the act doesn't give any clear indication. But in my view, understanding the nature of conversion, we can adopt remedies in the criminal jurisprudence, in the civil jurisprudence, and the constitutional jurisprudence. And the courts, in my view, are completely duty bound to ensure that the provisions of this act are protected for those who come to the doorsteps of these courts.
Now, there is a section 5 there, which is specific exclusion of Rama Janmabhoomi, because it specifically states that nothing in this act or none of the provisions will apply to this place of worship, which is known as Ram Janmabhoomi. So that is fine. Section 5, we need no, this is self-explanatory. Now, sir, talking about the role of Archaeological Survey of India, is there any exception? Are there any circumstances, if you can throw some light, wherein this nature can be changed, the alteration can happen, or if there's any evidence that suggests that, okay, fine, probably a couple of centuries ago something else existed here.
See, Jay, I will say that this, as far as your concern in respect of Section 5 is there, this position is now settled, and the Honorable Supreme Court, in its constitutional bench judgment in the matter of Ayodhya dispute, very clearly said the provision that how the place of worship will have to be seen. In fact, there is a observation in that judgment which says that this act will not be used for correcting the historical wrongs. And considering that the Supreme Court and its interpretation of this act, and that also a unanimous judgment by the 5 judges of our Supreme Court, the position is very clear that there may be a change in scenario, but if we strictly go with the definition of the act, it says that the the nature or the character of any place of worship as it existed on 15th day of August 1947 will have to be protected. In my respectful view, I feel that the Supreme Court has already clarified the position, including interpretation of the Act of 1991 in Ayodhya judgment itself, that the Act will have to be used only to protect breach and infringements occurring after 1947, 15th August 1947, and should not be used for any historical corrections. If you want, we can read the exact extract or the observations of the Supreme Court.
I think that is very well there, sir. So I don't think that is required.
Sure.
Now, let's switch to topic number two, which is
Sure.
constitutional law and its practice. First of all,
Sure.
a big thank you, sir, for doing the session on the provisions of the Act, which was very important. Uh, Now, talking about constitutional law practice, how can a young lawyer, a junior lawyer, or a law student develop, identify, cultivate his interest, his passion in the field of constitutional law?
Sure. So, Jai, before we move to the second topic, I would just want to share my views that the Act itself is a very self-enabling Act. The intentions were very good, and today, when the Act requires right interpretation, I think we will have to look at it from the nature or from the aims and objects of the framers of this act, of the framers of our constitution. And therefore, in my view, if this act prevails, it will surely benefit for several years to come to our country, and it will also ensure prevailing of peace. Your question regarding constitutional practice and regarding uh, how do we look at it? So, if you ask me particularly, I was a person who always thought when I wanted to become a lawyer that I will, since I am born and brought up in Bombay, we have a culture of attorneys, or what we earlier used to call them as, and now we call them as solicitors. So I was always inclined to do my solicitors and have a practice of a solicitor. In the year 2008, around 2008-9, I met with a very, very, very learned Jainacharya. His Holiness Acharya Shri Yugbhushan Suriji. During my interaction, which was the first interaction with him, which lasted for around 3.5 hours, this Jainacharya is, in fact, very much into understanding law, understanding the legal aspects, and ensuring that it benefits to the society at large. A Jainacharya to whom I would say, and I have never seen any such Jainacharya ever in my life, who understands the nuances of constitutional law. So he asked me a question about constitution at that time, and I was a second year law student. To him, or according to him, it was that if I am a law student, I must know my constitution. Unfortunately, in our schoolings in India, we don't have any formal way of making our students understand that what constitution stands for, what are the features of our constitution, what are the features of our part 3 of our constitution. So this Jainacharya somewhere inspired me by provoking my thoughts that why did I neglect understanding constitution? And since that time till date, I would have taken up various assignments in constitutional law, including few where we are, where I am part of of matters before Supreme Court, where we are dealing into questions of basic structure, where we are dealing into questions of determining that what forms the essential practices of religion, Article 25, 26 interpretation, where we are dealing with the fundamental rights and states' powers to interfere or to prevent its actions by putting certain acts under Schedule 9. These all are a pure constitutional matters which will require lot of deliberation, lot of consideration of the past judgments. These all things or these all matters, and I was guided by his wisdom, by the wisdom of His Holiness, to understand initially, and to now I've become part. I myself, I did not realize that how I got involved in it more and more. Later on, it became part and passion of my life. And today, it is not just my interest, but it is also a holy aim to stand for all those causes. And as a lawyer, and as a lawyer who loved to practice constitutional law, I would say, and I would share with my young friends and all the law students, that the practice of constitutional law is really satisfying. If someone asked me today that how do we develop our interest, then how did I develop my interest was my first judgment which I read was of Shirur Math and Keshavananda Bharati. Shirur Math is a judgment of 1951 Supreme Court, and Keshavananda Bharati we all know, the most prominent one. These two were the judgment which gave me an idea, the nuances of our constitutional interpretations, the nuances to understand that what our framers had in their mind while framing the constitution, and the benefits of the councils who argued these matters. Legendaries like Mr. Nani Palkiwala, who was capable to to present the whole issue before the full bench of the Supreme Court, the constitutional bench of the Supreme Court, to protect the liberties, to protect Part 3 at that particular time. We should be indeed thankful to him for such kind of efforts which were taken, which became a historical revolution in the history of our country. And those were the incidents, and those were the episodes which, when I went through those episodes, I started developing inclination to practice constitutional law.
Fantastic, sir. What a phenomenal journey this has been for you. Quite an inspirational one. And I'm sure all the viewers who are watching this will definitely benefit and understand why this field of law is so important and why aren't many lawyers opting for it, which is very unfortunate. Uh, Also, sir, how is this practice like? Is it very lucrative? I know it's such a very uh, silly question to ask, but do you think that's a very lucrative area of practice? Because the first thing that comes to mind of every young law graduate or a law student in his final year is, well, will I get a package from that? So unfortunately, that is how our thinking is. That is how the mentality is. But ultimately, do you think it's a very lucrative area, or is it a very satisfying field wherein even if you derive a lot of satisfaction?
Thanks, Jay, and I'm very happy that as a young lawyer, you're asking me this question. And see, the practice is extremely satisfying. As far as lucrative and those greener pastures are concerned, let me tell you that each and every lawyer has some role to play, maybe in their respective industries. Now, let us understand the role of a constitutional lawyer and the industries which benefit through their involvements. If you see the freedom struggle, we had maximum freedom fighters who gave their major contributions to get us independence were lawyers, and lawyers of their the best lawyers of their time, may it be on our side or may it be on the country who got partitioned from us. The founders were lawyers. in terms of understanding that how they will be planning the future of their country, what manner, etc., by framing constitution. Now, when a young talent or a fresh law graduate would think that whether he or she should consider constitutional law as their practice area, I would say, think of a scenario that today, if we come in this practice, our direct contribution is for the welfare of this nation. The laws are made, the laws are interpreted, the laws are reframed in our constitutional courts, and the structure like ours in India, where the third pillar of our democratic structure is judiciary. And in the testing times, judiciary has stood for the rights, for the privileges of its citizens. Keshavananda Bharati is one of such example. There are several such matters where even today where we see landmark judgments in respect of right to privacy, or may it be triple talaq, or may it be any such issues. Had we not had constitutional lawyers to take up this issue, probably the citizens or the large population of this country wouldn't have benefited out of the change or the reform or the revolution which came in. So the the benefits may be a little bit longer, or little bit like you may require patience to get the benefits of this particular practice. But if you see the way how this law, or the way how this practice has evolved, we had at one point of time legendaries, but today the the arena is getting a little bit dried up. And therefore my appeal, my request to the young lawyers, that please consider taking up this practice. Please consider having your patience retained in this practice, and the future is definitely good and bright for the practitioners in constitutional law in India.
Well, I still vividly remember the definition of constitution, the definition that was taught to us in school back in the days, that it's a body of laws according to which a country is constituted or governed. So you can imagine how important this field is. You know,
Yes.
it's such an important field, and yet uh, people don't generally don't think it as an option of even practicing and specializing in this field, which is very unfortunate. So I am sure that lawyers like you, seasoned lawyers like you, advocates like you will inspire a generation of lawyers to specialize, to opt for constitutional law matters, and subsequently contribute to the jurisprudence. Now,
So
sir.
Jay, so
Yes.
Jay, just sorry, but then I would like to also share the ideas as to how one inculcates or stimulates their interest. I mean, if you have a question to ask that, uh, okay. So what happened was, this is about me, and I was in my articleship days with a very senior solicitor in Bombay, and we were having Vodafone tax matter in our Bombay High Court going on a day-to-day basis, where I at that time saw two legendary lawyers, Mr. Salve on one side and Mr. Dr. A.M. Singhvi on another side, arguing this matter in the central court of our Bombay High Court building. So my senior immediately called me saying that, Bhavik, you go to courts every day, you attend our matters. So let's do one thing. Now onwards, the second part of your day, you will go and hear the arguments in this matter. I was of the view that this is a taxation issue. I had no idea about it, but it was considered with lot of constitutional interpretations, lot of interpretation regarding the applicability of this tax, etc. I started attending the court because the matter was listed at 3 o'clock on a daily basis. And I started attending. The first few days were that we were actually very bored in understanding the concept, what's happening, what's not happening. But as my senior told me and inspired me that retain your interest, just keep your eyes and years active as to understanding what is transpiring over there. Make your notes, come back, look for what was argued. If you can understand something from what was argued and from your notes, go back again. Jay, I can tell you with all assurances that this was an exercise for 20 days. And after those days, this became as a habit to sit in constitutional courts or to sit in high courts, even in matters where some good lawyers are arguing the matter, to understand their court craft, to understand the way how they present their matters, to understand the concepts which they elaborate in court while their arguments. The whole skill or that particular habit got developed in us. And today I can tell you that I got an opportunity to witness arguments in right to privacy matters where I especially went to Supreme Court only to witness the arguments which were taking place at that time. I got an opportunity to witness the arguments in Ayodhya matter, to witness the arguments the way how it took place, to understand the way how lawyers, the senior lawyers, the experienced lawyers tried to explain, interpret, and present their cases before these constitutional benches of the Supreme Court. Now, this particular habit of stimulating your interest, retaining your interest, and to develop the skills is very necessary even after 10 years, 12 years in practice. Today, if I have completed 10 years in practice, I can't sit with an assurance that now I know law, I know how to present myself in court. Trust me, this is a field where we have so many gems, so many seniors who's, who have various skill sets to present themselves in court. And we as juniors should never miss an opportunity to sit in courts, especially the constitutional courts, in High Court, Supreme Court, as and when we get opportunity to witness these arguments, to make our notes, to go back and research a bit, and then the opportunities are vast for you.
Fantastic.
Over to you, Jay.
Yes. There is a very there's one quote that I wish to read out that is by a very celebrated, very famous lawyer, Dr. Menka Guruswamy, ma'am, designated senior advocate from Supreme Court. That with the Constitution in our hearts, we go to our court to seek the removal of a colonial stain on our collective national conscience. This is what she said with respect to the 377 verdict. So that is how important the Constitution is, and that is how important the constitutional courts in our country are. Protect, safeguard freedom and speech. So, sir, lastly, I think we've already taken a lot of your time. And it's a Saturday, and you get just one day for you, for your family. Any parting words? Anything that you wish to say that we have probably not covered or missed out?
So, Jay, one thing what I would like to share with all the viewers is that we as lawyers have a lot of responsibility towards our society, towards our country. And as a lawyer, we are exposed to the society, the needy people who are looking for redressal of justice, who are looking for help from us. We all may have our respective priorities, but please consider doing some kind of contribution for the society in terms of using your skill sets, whereby we can return our knowledge, whereby we can return our 2 cents back to the society. The chain of such humanitarian acts will create a positive environment whereby today the image which our profession is facing, that we may not be very friendly, or at one point of time the image which we all had of a noble profession requires to be regained, number one. And at the same time, our contribution for the society, for the benefits of the needy people, for the benefits of of our future generation by getting involved in matters which will have constitutional repercussions should not stop. We have lawyers from the walks of corporate practice, civil practice, and variety of other practice areas in India. Each and every practice has its role in contribution for the welfare of society, for the welfare of nation. So, if we can consider taking up our respective roles in our capacities, in our limited capacities, maybe, this will surely send a very, very, very strong message to all. And also, we should support our fresh lawyers when they come to us in whichever manner we can, because these are our future. These are the torchbearer of this institution, of our judiciary, of our country. And if they get initial support, I'm very sure that these people will make us proud one day. And therefore, my message to all the established lawyers that please consider supporting junior lawyers, please consider supporting the law graduates. And my message to all fresh law graduates that consider the constitutional practice as one of the priority if you have interest in it, or if you can consider exploring whether you have interest in it. The prospects are bright, the prospects are beneficial to you, the prospects will satisfy you with your services, with your practice. And also, I would like to thank you, Jay, that uh, you have taken an initiative to understand a very dry area of constitutional law from a lawyer who is still not very seasoned, who is still a junior. Before we conclude, I have some people who have really supported me of making me what I am today. And in that list, I have first my spiritual guru, His Holiness Yugbhushan Suriji. I have my seniors with whom I have worked. I have been groomed. My senior, Mr. Sanjay Jain, a counsel practicing at Bombay High Court with 25 years of standing at the bar, and all my colleagues who have been my friend, philosopher, guide throughout this journey, helping me to understand and to establish myself in an area of law which is a challenging but which is also a very self-satisfying.
Well, sir, I wish to compliment on this brilliant presentation, and it was a very insightful session indeed. I'm sure our viewers will immensely benefit from this, because for the first time on the virtual Americas, you had a speaker who dealt with constitutional law and who also dealt with nuances of the Place of Worship Act, two topics not covered before. It's been more than a year of recording, so thank you so much, sir. For amassing all the courage and dealing with two really very important areas, two very important topics. And well, we all are in a profession of persuasion. Uh, I think obsession should always be with excellence, with knowledge, and not with packages. And I'm sure that when once you start excelling in the field of your choice, of your passion, then wealth and package will automatically follow. And let's not
If in
forget that we're in a
case,
profession.
yeah, if in case if there are any queries, any
Yes.
concerns which require my consideration, my contribution, you and the viewers will be are free to get in touch through you to me, and I will sure to I'll make sure if I can respond to them in whatever manner, or I can contribute to them in whatever manner I can.
Absolutely. So, to all the viewers who are watching, email is mentioned on the channel, and feel free to write to us on any of the queries on fundamentals, topics, whatever we have covered. In case of any doubts, write to us. We'll be more than happy to forward the same to our Amicus for today's session, Mr. Bhavik Lalan. And you can even write directly to him if you deem it appropriate. It will be totally as per your convenience. And thank you so much, sir, once again for taking out time for doing this session. Really means a lot to me and my entire team. And it's goodbye for now.
I would request you to keep continuing these sessions for the benefit of all our young lawyers, our law students. and my best wishes to your whole team, Jay. Thank you very
Well, if
much.
we keep getting speakers of your stature, then I'm sure this will go on forever. So
It
thank
will.
you.
It will. Thank you very much.
Thank you so much.